We will hear argument this morning in Case 20-843, New York State Rifle and Pistol Association versus Bruin. Counselor Gutowski, Counselor Shore.
Thank you, Your Honor, and may it please the court. In September of 2014, petitioners Robert Nash and Brandon Coach applied for unrestricted concealed carry licenses in the state of New York. Both men had no criminal history and cited self-defense as their motivation to apply for concealed carry permits. New York licensing officers found that neither man established proper cause for unlimited carry licenses, but both men were granted the ability to use their handguns for target shooting, hunting, and other outdoor activities away from densely populated areas. Additionally, Mr. Coach was authorized to carry his firearm to and from work. Petitioners sued in the U.S. District Court for the Northern District of New York on the basis that New York's proper cause requirement violates the Second Amendment. The district court dismissed the case, citing the Second Circuit case Kachalski v. County of Westchester, wherein the Second Circuit found that regulating firearms carried in public is subject to intermediate scrutiny, and New York's proper cause requirement satisfies intermediate scrutiny because it is substantially related to the interest of public safety and crime prevention. The Second Circuit summarily affirmed.
Today, we argue that the proper cause requirement in New York's law is in fact constitutional and does not violate the Second Amendment. American and English law have for centuries limited the carrying of firearms in public in the interest of public safety. From the founding to the present, 20 separate states have prohibited carrying arms in public greater than or to the extent of New York's law, which itself has existed for over a century, placing it well within the Second Amendment's history and tradition. The case District of Columbia v. Heller instructs that text, history, and tradition on their own can be used to validate or invalidate a law under the Second Amendment. And where the history cannot account for new conditions of modern firearms, this court should use the test of intermediate scrutiny. Because New York's law is substantially related to the interest of ensuring public safety and is consistent with the text, history, and tradition of the Second Amendment, we urge a decision in favor of the respondent.
What does the Second Amendment protect?
The Second Amendment reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, the Second Amendment is unique in the Bill of Rights in that it actually has a clause that specifically tells us what it's for. It's to protect this security of a free state. And the term free state can be interpreted to have two different meanings. The protection of state sovereignty, or to protect the system of federalism, as well as the protection of an individual right to self-defense, in the case that you're interpreting free state to mean the collective people of a free nation. When reading that the Second Amendment protects state sovereignty, we can look to the DC Circuit case Parker v. District of Columbia, which provided the amendment was drafted in response to a perceived threat to the freedom of the states posed by a national standing army controlled by the federal government. And United States v. Miller, which was a landmark and the dominating Second Amendment case for almost 70 years before Heller, also provided that the Second Amendment guarantees no right to keep and bear a firearm that does not have some reasonable relationship to the preservation or efficacy of a well-regulated militia. However, state has also historically and at the time of the founding been used to mean country, and free, the term free, to simply mean free from an oppressive form of government. And this was the context in which free state was referred to in Blackstone's commentaries, as well as in the writings of Madison and Adams at the time of the founding. And as the case Parker v. District of Columbia concluded, free state, the term free state referred to a free country and not an actual political unit of the United States like New York. And this reading supports the individual right that was recognized in Heller, and that is the right to keep and bear arms for the core lawful purpose of self-defense. The meaning of the right of the people in the Second Amendment can therefore be understood in a similar way as to the First and Fourth Amendments, which is referring to a right of the people as free individuals, even if it is still a right that is partly justified by public interests. And so therefore, this right, as is confirmed by Heller, applies to all Americans, regardless of whether they're actually a part of any formal militia.
So why did the framers include the Second Amendment in the Bill of Rights?
Well, as discussed in response to the last question, one protection of the Second Amendment, as it was originally intended, was to stop Congress from disestablishing and disarming state militias using the powers it has in the Constitution in Article 1. And so this therefore protects state autonomy. And so this meant in practice that individual states could determine gun regulations, and we see that they did. The Massachusetts Constitution in 1780 provided that the people have a right to keep and to bear arms for the common defense. And in times of peace, armies are dangerous to liberty, they ought not to be maintained without the consent of the legislature, this being the state legislature. And a similar notion, a sort of sentiment, was later echoed by the Kansas Territory Wyandotte Constitution of 1859, which said that the people have the right to bear arms for their defense and security by standing militias in times of peace. But standing militias in times of peace are dangerous to liberty and shall not be tolerated, and the military shall be in strict subordination to the civil power. And this again, rearticulating the fact that these militias must still be well regulated. However, if we're looking for where the Second Amendment was derived from, we can look to the protections of English common law at the time of the founding. And the US Constitution's Second Amendment articulates a right which was already included in the English Bill of Rights in 1689, which said that the subjects which are Protestants may have arms for their defense suitable to the conditions and as allowed by law. And Heller refers to the right provided in the English Bill of Rights as the predecessor to our Second Amendment. We see where this link is direct, there's a direct link here. And Blackstone in 1865 in his commentaries reiterates that important phrase in the English Bill of Rights as allowed by law. Citizens have a right to arms for their defense suitable to their condition and degree and such as are allowed by law. And Blackstone also says that this right is by its nature a public allowance under due restrictions of a natural right and resistance and self-preservation when the sanctions of society and laws are found insufficient to restrain the violence of oppression. So Blackstone clearly articulates that while there might be rights of resistance and self-preservation that are recognized as natural rights that were meant to be protected in the English Bill of Rights, and as we can relate, it's subsequently protected in the US Constitution's Bill of Rights, these rights exist in every condition only to the extent as is allowed by law and under these due restrictions. And so the Second Amendment has historically balanced both interests.
What are the limits of the Second Amendment's protections?
The Second Amendment does not create an unlimited right and is restricted by balancing public safety with the rights of an individual, according to Heller. Heller established the most recent precedent regarding the right to keep and bear arms. In this case, Justice Scalia stated explicitly that the keeping of arms within the home is a core right, this being the right to self-defense within the home using deadly force via a pistol. In Heller, the court examined the history and tradition of English common law and the American Constitution in order to determine the limits of the Second Amendment's protection. Justice Scalia explained that the right to keep arms has been protected as a fundamental right since the founding of our country. After coming to the conclusion that the Second Amendment solidified this pre-existing right to protect the security of the free state, Justice Scalia made the important distinction between the terms keep and bear. He explained that the keeping of arms within the home is a fundamental right established by the Second Amendment, whereas the bearing of arms outside the home is not. The court acknowledged that there has always been a stricter regulation on the bearing of arms due to the harms it imposes on public safety. This is also supported by English common law. If we look to the Statute of Northampton in 1328, we see that no man, great nor small, could go nor ride armed by day nor by night nor by day in fairs and markets nor in no part elsewhere. Other statutes and laws from as early as 13th century banned carrying of guns after curfew in Parliament and in churches. There are a few different ways of determining if laws restricting the right to keep and bear arms are constitutional. Haller instructs the scope of the right is determined first with the text of the Second Amendment, then with the history of the right to keep and bear arms, and lastly with the tradition of arms regulation in the United States. We believe that this history and tradition test can be paired with one of the balancing tests, in this case, intermediate scrutiny, due to the substantial interest governments have in public spaces to preserve public safety. On top of this, we believe that text, history, and precedent urge that the Second Amendment requires governments to leave responsible citizens ample means for self-defense at home and outside. As established in Wren v. District of Columbia, a regulation's validity may turn partly on whether surrounding laws leave ample options for keeping and carrying. This is harmonious with Heller, which provides that if a law makes it fundamentally impossible to exercise a right, such as this right to self-defense, then the law is unconstitutional. Only by using all of these tests can you draw the line between protecting public safety and one's right to bear arms.
What weapons does the term arms include?
Well, in order to determine what weapons the term arms includes, we can look to arms as it was used in the context of the founding. And we can look to Madison's words in Federalist number 46, where he writes that it may well be doubted whether a militia thus circumstanced could ever be conquered by such a proportion of regular troops, those who are best acquainted with the last successful resistance of this country against British arms will be most inclined to deny the possibility of it. And so Madison here is referring to the British invasion generally in his use of arms. So it can be interpreted that arms includes all forms of the weaponry used by the British for the purpose of war. And Madison goes on in the next line to describe the advantage of being armed, which the Americans possess over the people of almost every other nation. And in this line, you can see that he's specifically referring here to the ownership of firearms, because this would be the only thing that is unique for Americans having the right to possess specifically. And so drawn from this, arms in what he's referencing can be taken to mean all forms of weaponry that would be included in an organized militia, whether that be firearms, cannons, naval forces, etc. However, if we're just looking at the text, taking, for instance, Blackstone's commentaries, these commentaries actually seem to have treated the words gun, pistol, weapon, and arms as slightly different things. And as we outlined more extensively in our brief, gun only appears in passages about hunting, pistol only appears in passages about talking about crimes, including murder, manslaughter, and instances of otherwise disturbing the peace. And in specifically referencing arms, when Blackstone specifically references arms, he says that you can ban arms from large assemblies. When we read that he writes, persons attending public civil meetings with arms, bludgeons, flags, banners, etc., are subject to fine and imprisonment for any term not exceeding 2 years. And so what this collectively suggests through Blackstone's commentaries and through Federalist Papers, this suggests that any weapon, as we know today, the Second Amendment specifically applies more so to firearms. This right to be armed that Madison earlier mentions, that regulation of arms in public places still is permissible. And we believe that this is something both sides in this case can agree on. And what we simply disagree on is to what extent those regulations go.
What is the difference, if any, between the verbs keep and bear?
In Heller, the court made an important distinction, as mentioned before, between the terms keep and bear. Justice Scalia stated that Johnson, a dictionary relevant during the time of the founding, defined keep as to retain, not to lose, and to have in custody. Webster defined it as to hold, to retain in one's power or possession. Thus, the most natural reading of keep arms in the Second Amendment is to have weapons, this being to possess weapons in the home, as Heller interpreted. As we've seen throughout history, the natural meaning of bearing arms was unambiguously used to refer to the carrying of weapons outside of an organized militia. The most prominent examples are those most relevant to the Second Amendment. 9 state constitutional provisions written in the 18th century, which enshrined a right of the citizens to bear arms in defense of themselves and the state, or bear arms in defense of himself and the state. This can naturally be linked to the carrying of guns in public, existing under the meaning of the word bear, and bear is the right we look to in this case.
What is a militia, and why did the framers refer to it in the Second Amendment?
Well, to answer this question, as we've already discussed today, the DC Circuit case Parker v. District of Columbia recognized that the Second Amendment was drafted in response to a perceived threat to the freedom of the states posed by a national federal army. And so here, militia in the context of the Second Amendment refers to state militias and the right of the people to form a militia independent of the federal government. And this is the main really reason that we can look to see why the framers included this. Yet District of Columbia v. Heller, Justice Scalia wrote that the phrase bear arms against always refers to service in a militia, but bear arms by itself, as he interpreted it, and as it is written in the Second Amendment, it does not say against. Following this can sometimes refer to an individual right. And so in that context, the framers ensured that the security of a free state to be protected by state militias. And by doing that, they created an individual right to keep and bear arms within the home, as interpreted by Justice Scalia in the case of Heller. And so this means that it is under the Constitution, it is imperative that each citizen has the right to keep a gun within their home. And this is explained by Justice Joseph Story in his A Familiar Exposition of the Constitution of the United States, written in 1834, when he says, one of the ordinary modes by which tyrants accomplish their purposes is by disarming the people and making it an offense to keep arms. And so what we see is that the framers crystallized the right in the Second Amendment because they wanted to ensure that the citizens of America would not be subject to tyranny.
So how should courts determine if a gun control regulation is considered long-standing?
The language long-standing, referring to the Second Amendment, actually comes directly from Heller, when Justice Scalia refers to long-standing prohibitions in his majority opinion. And he writes, the court's opinion should not be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons or the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. And most of these prohibitions that he talks about in the context of being long-standing, these only date back to the 1920s, some of them being as recent as the Gun Control Act of 1968, which means that this court can still consider these innovations in gun history, gun law and precedent rather, to still be considered long-standing. And so this also means that overall, we can see a long-standing tradition of may-issue regimes limiting the carrying of concealed firearms in public in this country, because several states have enacted these regimes in the same time span that the prohibitions Justice Scalia references were made. And so therefore, they can also be viewed as permissible under the Second Amendment. And we can see specific examples of this. There were laws that either prohibited or required a showing of good cause to carry a concealable weapon, like a pistol, as early as 1820 to 1821 in Tennessee. Texas followed in 1871. And we see that the states New Mexico, Arkansas, West Virginia, Alabama, Massachusetts, California, and Hawaii all enacted similar laws in the same time span that Justice Scalia refers to as long-standing. And we see that New York's law itself, its revised Sullivan Law from 1913, can itself be considered a long-standing prohibition under this definition.
What is strict scrutiny? Intermediate scrutiny? Rational basis review?
Strict scrutiny, intermediate scrutiny, and rational basis review are all different types of tests used to balance a state's interest against an individual's right. As we have seen throughout English and American common law, there is a fine line between protecting public safety and protecting an individual's rights. In Marbury v. Madison, the Supreme Court declared an act of Congress unconstitutional, thus establishing the doctrine of judicial review, a very important check in today's powers. Rational basis review is generally used when there are no fundamental rights in question or suspect classifications. To pass the rational basis test, the law must have a legitimate state interest, and there must be a rational connection between the law's means and goals. The next level up is intermediate scrutiny, which is invoked when a state or federal government passes a law which negatively affects certain protected classes or rights. To pass this test, the law must further an important government interest and must do so by means substantially related to that interest. This test was created in Craig v. Boren in 1976, where the court used it to evaluate a statute which discriminated on the basis of gender. The differences between strict scrutiny and intermediate scrutiny is that strict scrutiny is invoked when a fundamental right is in question, or for certain discrimination lawsuits against the government. Another difference is that the legislature must have passed that law to further a compelling government interest and must have narrowly tailored that law to achieve that interest if the law wants to survive strict scrutiny. Now, strict scrutiny was created in footnote 4 of Caroline Products. This footnote explains that certain legislative acts might give rise to a higher level of scrutiny. For example, if a law appears on its face to violate a provision of the US Constitution, especially in the Bill of Rights, or if a law restricts the political process that could repeal an undesirable law, and lastly, if it discriminates against discrete and insular minorities. But again, the test of intermediate scrutiny is used in this case due to the fact that a fundamental right is not at question and the government has a very important interest in the right of public safety.
So, is there a difference between openly carrying a firearm and concealed carrying a firearm?
New York, like many other states, restricts the open carrying of firearms to a greater extent than it restricts the concealed carrying of firearms. It does not permit the open carrying of firearms at all. This is because openly carrying arms has long been understood to be more dangerous than carrying a concealed weapon. Blackstone in his commentaries refer to being armed with offensive weapons to the breach of the public peace and the terror of His Majesty's subjects, suggesting that offensive weapons in view are more dangerous to public peace or safety. Additionally, according to Everytown for Gun Safety, research shows that the presence of a visible gun makes people more aggressive and can quickly escalate situations. So some might point to the 1846 case of Nunn v. Georgia, which, though it was long before Heller established that the Second Amendment protects an individual right to self-defense, it was written in Nunn v. Georgia, it is only when carried openly that weapons can be efficiently used for self-defense. Yet, Nunn v. Georgia is flawed because it struck down a state prohibition on openly carrying weapons, even though the Second Amendment wasn't incorporated until 1868, and the right to self-defense under the Second Amendment didn't apply to the states until 2010 in the case of McDonald v. City of Chicago. More importantly, Nunn v. Georgia still upheld a concealed carry ban in the state of Georgia. And as this court stated in Robertstown v. Baldwin in 1897, The right of the people to keep and bear arms is not infringed by laws prohibiting the carrying of concealed weapons. Heller itself also recognizes that the majority of the 19th century courts to consider the question held that prohibitions on carrying concealed weapons were lawful under the Second Amendment or state analogs. Because the petitioner's complaints in this case are related to concealed carry and not open carry precedent has little bearing on the case at hand.
So how should the court determine the public safety implications of licenses to carry firearms?
Safety or security is the principle and purpose inherent in the text of the Second Amendment. It naturally flows from the text and structure of the Constitution that research can illuminate the ways in which firearm regulations can ensure that the exercise of the right to bear arms maximizes security interests. Congress was empowered to invest in these discoveries. Article 1, Section 8, Clause 8 of the United States Constitution grants Congress the enumerated power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. As established by Heller, one can keep and bear arms in the home because our Constitution establishes an individual right to keep and bear arms to ensure protection against tyranny. Justice Scalia elaborated on this, explaining that the right to self-defense within the home via the use of a pistol is inherently a fundamental right because it is a long-withstanding tradition codified by the Constitution. Explained that when balancing the interest of a citizen's ability to bear arms within the home with public safety, the benefit, assumed benefit, or the benefit a citizen obtains when given the ability to exercise a right buried deep within the history and tradition of our country is greater than the harm doing so imposes on public safety. The court's only job is to ensure that surrounding laws leave ample options for keeping and carrying, as stated before. As long as the citizens have the choice to bear arms when they are considered to be in an inherent danger, the state's laws are constitutional. If petitioners Nash and Kosh had a good reason to believe that they were in danger unique from the dangers their fellow citizens face on a day-to-day basis, and then they were denied an unrestricted carry license even after providing proof, only then would their right to keep and bear arms have been unconstitutionally restricted. The way our Constitution was designed allows for each state to have unique licensing regimes. The Supreme Court can ensure states provide citizens with the ability to keep weapons within their home and bear weapons on the street as long as their circumstances deem it necessary, but no more. Thank you.
Thank you, counselors. The case is submitted.